All right,
Yes.
fantastic. Okay, so let's make sure that I can advance my slides. So we've covered who I am and why I'm here today. For anyone who doesn't know about Disability Rights Vermont, we are the protection and advocacy agency for the state of Vermont. The P&A system is national and covers all the states and territories. There are P&As in every single one. And they originated out of a series of legislation enacted by Congress following an expose that Geraldo Rivera had done, exposing some pretty egregious conditions in a school in New York called Willowbrook. And so from there really was this federal mandate to protect and investigate and monitor treatment environments for people with all types of disabilities, starting with individuals with developmental disabilities and over time broadening to really encompass and protect all people with disabilities. There is a link in the slides that you will be receiving to watch a brief video kind of about the broad scope of that work. So feel free to check that out. So just high level, really broadly, what we do is we do investigate complaints of abuse and neglect and rights violations. We are a nonprofit law office, so we really are rooted in the legal rights and enforcement, but our mission is really to promote self-advocacy and advance people's rights and their ability to thrive in their communities and have their rights protected. So we also do a lot of education and advocacy work and promoting self-advocacy and systems change. We do trainings like the one that we're doing today, and we do this in a broad variety of ways. We provide information and referral, we do our investigations. Occasionally we will provide litigation assistance when all of those other steps have failed. And we try to be in the legislature and educating our policymakers about what needs to be changed. I have a tendency to talk fast as well, so please, if I need to slow down, give me some sort of a flag that will prompt me to do that, because I can speak a little bit quickly. Okay, so for today, I'm hoping that we just understand kind of the what, why, how, who, when of advanced directives, and then also understand the resources that are available to assist you and the people you're working with or your family members to executing and completing these really important documents. So diving right in, what is an advanced directive? It is a legal document that allows you to kind of outline your healthcare preferences. It is limited to healthcare preferences. There are other legal documents you can execute that would allow you to give another individual the ability to make other decisions for you, like financial decisions, legal decisions, and the like. But advanced directives are really focused on your healthcare preferences and end-of-life choices. It is any written communication from you that's properly signed and witnessed that talks about your future wishes and preferences. There is no specific form that you have to use, but there are a variety of different options that do exist from Disability Rights Vermont. The Vermont Ethics Network has a couple of forms as well, but you could be sitting in a restaurant and have an 8x10 piece of paper or a napkin, and you could have that properly witnessed and signed by two people that just identifies, maybe it's just an agent, and that could be an advanced directive. So there is no specific form. It used to be known as like a living will or a durable power of attorney for healthcare. So why is it important to create an advanced directive? As I said, it's really about your ability to retain your autonomy at times when you don't have the capacity or the ability to communicate what your wishes are in that moment. So it's really about preserving autonomy and continuing to promote person-centered choices and treatment planning. And it's useful because we can't predict the future. We never know what's going to happen. So it's really important to complete these documents at a time where we've got space and the capacity to think these decisions through because we never know what tomorrow will bring. So self-empowerment, to retain that control over your own decisions and treatment, and to provide really clear directions to those who may be involved in your life that may not fully understand what your needs are or what your wishes are. and to have somebody else designated to help make those decisions. So who can execute an advance directive? Any adult with capacity who does not have a guardian appointed. We can talk a little bit about that. I think I go into a little bit more detail later, but yes, if you do have a guardian or if you're working with individuals who have guardians, then you cannot technically execute an advance directive and have that be a legal document. But certainly completing the content of what an advance directive provides and how it guides what your wishes are. There are expectations and rules for guardians that would really require them to still follow the content of what you've put down as your healthcare preferences, even though the document itself wouldn't be a validly executed advance directive. So we can talk about that a little bit more because it may be confusing. And capacity is an individual's decision or ability to make and communicate a decision regarding the issue that needs to be decided. So it's very situational. It's not like competency when you're in like a legal proceeding, for example, which is a legal determination about your ability to understand the process and the ramifications of your choices. It's about, you can have capacity to make a decision around using a ventilator, for example, and you can not have capacity to make some other determination. So it's very, it's a medical determination, and people are presumed to have capacity. So if you're in the community and you're thinking through these things and you're trying to be proactive, capacity is presumed. And so, you know, we're presumed to have capacity to make all of these decisions, but it is situational as well. So there are times when you may not have capacity in certain contexts. And that will come into play when we talk about like when an advance directive goes into effect, because there's a few different triggers that can, you know, make it so your advance directive is coming into play when you want it to. So as I said, decision-making capacity is not the same as competence. It's not an all or nothing assessment. So how do you execute an advance directive? So you can use any form you choose as long as it's dated and signed in the presence of 2 or more witnesses. The witnesses also have to be adults. So they'll sign and affirm that you appear to understand the nature of the advance directive and that you did it voluntarily and of your own free will. The witnesses don't have to read your entire advance directive. They don't have to go through your advance directive with you and agree with your decisions. They just have to be somebody who can say, this person seems to understand what this document is and that they're signing this of their own free will. The witness cannot be a person you designate as your agent or your spouse, civil union partner, a parent, child, grandchild, or other potential heir. So in certain contexts, for individuals who might be determined to be slightly more vulnerable because of their status in a hospital or residential care home or in a nursing home where they're already having their autonomy restricted in some way, you can still execute an advance directive in those settings, but there is an additional requirement that comes into play where an additional person has to sign off that says like they've explained what an advance directive is to the person and that they still seem to understand what that is. There's a variety of different people who can be this explainer. In hospital settings, there are patient representatives. It can be the long-term care ombudsman or the mental health ombudsman. I will say that Disability Rights Vermont is the mental health care ombudsman for the state of Vermont. However, we don't typically explain or witness advance directives. We help people complete them, and then we suggest that people receive witnesses from other persons, just because DRVT can also be a mechanism for enforcement when an advance directive is not followed. So we try to avoid that conflict and don't often witness or explain the advance directive. We just assist with completing them. So other people who can help in these particular facility settings when somebody is wanting to execute an advance directive would be a member of the clergy, another attorney, a probate court designee. Hospitals may have somebody called hospital explainer. If you are in a nursing home or residential care facility, you could also have a volunteer be the explainer of this advance directive, so long as they're a volunteer and not getting paid for their work in that facility. I'm gonna just stop for a minute because I also don't like just talking at people. So I don't see, is there anything in the chat that I need to respond to yet?
We don't have any questions yet.
Okay.
But please feel free if you do have a question to type it in for Lindsey.
Okay, so that person, if you are in a residential care home or a nursing home or in a hospital, in addition to explaining that to you, they will also have to sign off on the advance directive that says that they've done that and they're affirming that they've provided you with that explanation. And that person can also then serve as one of the two witnesses. So you don't necessarily need three witnesses in those settings. The explainer could also be one of your two witnesses. So as I mentioned before, there's no specific form. There are some forms available to you. The Vermont Ethics Network has a lot of great information on their website, and they've got a longer form. They've got a shortened form. And then they also have a form that just allows you to identify an agent. Whatever form you choose to use, you don't have to complete the entire thing. So for example, Disability Rights Vermont has a longer form that includes psychiatric preferences for treatment. That may be all that's important to somebody, and they're not ready or wanting to make those end-of-life decisions around resuscitation or feeding tubes and all of those decisions. What they are focused on right now is their psychiatric care and being able to instruct around those types of preferences. And so it's okay to complete to pick and choose what sections of an advance directive you want to complete. It is still valid if you've gotten it signed by those two witnesses and dated. So you don't need to complete the whole thing. It can be kind of overwhelming to make all of these decisions. So that's something that I think is really important to know that I think often gets lost or forgotten about. So it can be a lot. And there are different forms. Dale also has a form for appointing a healthcare agent. And then there's also a form for do not resuscitate and a clinician order for life-sustaining treatment. And that's something that if that's really, really important to you, I would recommend that you complete that form as well as an advance directive. And that's because for emergency services, if you're being responded to in emergency service and you have a DNR on record, like that'll be more easily for the emergency personnel to find versus an advance directive that someone may have to look up on the registry that may not be something the ambulance personnel are going to be able to do in an emergency. So let's see. So as I mentioned, there are a lot of different parts and you don't have to complete all of the different parts. Part one is identifying a healthcare agent. You do not need to identify a healthcare agent. If you feel like there isn't somebody that you can think of in your life that would serve well in that role, or maybe you don't have, or the person you're working with doesn't have that type of support or connection and they're unable to identify an agent, that's okay. You can still complete all of your preferences. The healthcare providers that will then see you still need to follow your advance directive, even if you haven't identified an agent. The only section that requires an agent is the Ulysses Clause section. And that's a section we'll talk about later. It's a little bit complicated, but it can be really, really useful for specific situations. So it's broken down, ours is broken down in this way where you can identify your agent, you can talk about your overall healthcare goals and spiritual wishes. Part 3 would be limitations of treatment, other specific instructions, for example, hospitals that you want to try to avoid, things that reduce your symptoms or make you more comfortable, things that may make the situation worse, medication preferences, and things like that. ECT preferences are in that section for Disability Rights Vermont. Part 5 is the waiver of right to request or object to treatment. That's the Ulysses clause that we'll get into a little bit later. Part 6, if you're wanting to think about organ and tissue donation, and then Part 7 is where you would have the signing of the witnesses. Okay, so the agent would be an adult who also has capacity, who you've appointed as having the ability to make these decisions for you when you don't have the ability to do so yourself. It cannot be your healthcare provider. And it can't be somebody employed by the healthcare facility or correctional facility where you're residing at the time you execute your advance directive if you're in that situation. You also have the ability to appoint alternative agents, co-agents, and that, for a variety of reasons, there are pros and cons to having co-agents, and that's just an individual determination that you'll think through kind of on your own about whether or not that might work. And again, maybe that's a situation where you want your children to be, collaborating around decision making, or maybe not. Maybe that, I know in my family that may not be the best route to take. And you can identify others who you may want to be consulted. I think on the Ethics Network forum and DRBTs, there's also a space to say, do not talk to so-and-so about this. So you can identify who to talk to and who you do not want to be consulted. So as I mentioned, you can absolutely still execute an advance directive even without an agent, as long as you get it signed by those 2 witnesses and dated. With the exception of that Ulysses clause. And then you can choose when your advance directive goes into effect. So for example, I'm working on one for my aunt right now where she's just identifying an agent. And so she wants it to go into effect now because, she wants that just to be something that's in place, doesn't have to think about it anymore. And so it could also be, when a clinician has determined that you don't have the capacity to make those healthcare decisions for yourself. And it could also be when a particular condition that you know that you're going to want some support in advocating for your treatment preferences when that condition presents itself. And for the Ulysses clause, it would go into effect when 2 clinicians have determined that you lack capacity. Okay, so you can do all of these great things. You can do your advance directive and identify all these preferences, and then in the moment while you're in this situation and a treatment decision needs to be made, and you decide to change your mind, that your healthcare provider should still be listening to what you say in that moment, unless it's contemplated and outlined very specifically in a Ulysses clause. So you can say, I don't want this type of treatment. And then in the moment say, you know what, never mind. I really do want you to try that. Your healthcare provider should still be listening to you at that point in time when you're making that healthcare decision. Let's see. So they also should follow the instructions of your agent and or the instructions contained in your advance directive. There are some exceptions. If the instruction, let's say from your agent, is clearly inconsistent with what's in your advance directive, and a healthcare provider can also refuse to follow it if it would cause the provider to violate any criminal law or a standard of professional judgment. And so they could also refuse because of a moral, ethical, or other conflicts, but they would have to get another provider to come into the situation if that were to be the case. Okay, so there's a little Q&A that just popped up on the side that says, what if a medical provider does not honor an advance directive? They can be referred to the relevant licensing board. Disciplinary action could follow. That is also a time where you could reach out to Disability Rights Vermont. We have certainly had that issue come up. Usually we see it in emergency department settings where somebody is being held for involuntary treatment or for an emergency examination, and they receive some form of involuntary medication where their advance directive has clearly said, I do not want antipsychotic medication, or I do not want this specific antipsychotic medication. If that were to happen and that medication were still to be provided, you could reach out to Disability Rights Vermont. We could potentially investigate and try to resolve that complaint through either a grievance or some sort of legal process to try and resolve that and clear that up for you and have it be enforceable in the future. We certainly have done that in the past. And it really depends, like our approach would depend on the severity of what happened and the injury that was caused. Of course, anytime anyone receives involuntary chemical restraints, that's incredibly harmful and traumatic. And then even more so if it's been specifically something that's prohibited by an advance directive. Okay, so Vermont is a small state. We're surrounded by a bunch of other states. So do advance directives work across state lines? The answer is most of the time there's a reciprocity amongst the states. What we do say is that some states require that they'll honor an advance directive if it also meets their state's advance directive law. So for example, I think New Hampshire might require that advance directives be notarized. So when we're working with individuals who frequent other states or they've got a lot of family members in another state, we recommend looking at that advance directive law as well to see what the law says about reciprocity and whether or not what the requirements are if they require their own state law to be followed. So if you've got a lot of family that you see in Massachusetts and they require it to be notarized, there's nothing that says you cannot have your Vermont advance directive notarized. It's just not a requirement of our state. So again, for people that are traveling or have family member out of state, that might be something to look into to just make sure it's going to be honored in those other states. Okay. Okay, so another great thing to do is register your advance directive. Now that's something that's done right at the Vermont Ethics Network. So you can just submit that to them. It's free. You can update it at any time. What happens is then this registry is available to all hospitals throughout the state. So as soon as you are admitted to a hospital, they have to check to see if you have an advance directive. So registering it is really important. It used to be the case that a lot of people would complete their advance directive, give it to their agent, give it to their primary, and then that is where it would land. And so a lot of times it wasn't something that was being picked up on by hospital staff. So registering an advance directive is really critical to making sure that wherever you end up, people are going to be aware of what your preferences are. You're not required to register it, of course, but I think if you're really wanting to make sure that there's a consistent approach to your healthcare preferences, that would be the way to go. Okay, so how do you register it? You can return a copy of it by email, you can mail it to the Ethics Network, you can fax it, and then you can also check out their website for more information. And as I said, Disability Rights Vermont is also available as a resource to do any of these things. When we help people complete their advance directives, we also help ensure that everything that's in the advance directive is consistent with one another. There used to be some questions asked that would result in an inconsistency. And so there would be, like, for example, you want nutrition assistance, but you don't want to be intubated, and there's no way to do the one without the other. And so DRVT would provide that sort of oversight to make sure that everything in your document is consistent so that your preferences are most likely to be carried out accurately. And then we can also help it get registered, and we would retain a copy of it for ourselves as well if you needed another copy in the future. So, how do you amend, revoke, or suspend your advance directive? Um, as I said before, so even in the moment, if you're in a hospital and you're needing to undergo some sort of treatment that you've said in your advance directive, you do or don't want, you can change your mind, even if you don't have capacity, except if it's something that's listed in that Ulysses Clause section. And then if you want to amend or make changes to your advance directive, you do have to legally execute a new one. So revoking something or suspending something, you can just do in the moment. If you want to make a change to it, you will want to legally complete another one and get 2 new signatures. All right, I'm still just talking at everyone. I hope it's not too overwhelming.
It's a lot of good information, Lindsey.
Okay. Okay, so back to this Ulysses Clause, or the waiver of right to request or object to treatment. So, for example, I have a family member who, in a moment of crisis, is very much adamant against accepting treatment, and then after the crisis has settled and they're stabilized, they recognize like, oh, you know what? I know that this would have actually been really, really helpful. This would have helped me get stable faster, and I want that to take place, even though I know in that moment I'm going to be objecting to it. So, for example, maybe there is a particular medication like lithium or whatnot that somebody, as their mental health is destabilized, will be adamant against taking, but when they have capacity, they know that lithium is really, really helpful for them and will help them restabilize. That may be somebody who wants to do the Ulysses Clause that says, I know that I'm going to refuse that, but I also know that that's what's best for me. So I want to sign this Ulysses Clause so that even when I'm objecting to it, they're still going to be able to give it to me. It's a really not controversial, but it's a really complicated, fact pattern to kind of work through and like thought process to undergo. But I think there are people that DRBT has worked with and my own family members who have kind of gone through enough of these crises to really feel like, okay, this is what's best for me. And this is when there does have to be an agent appointed, because you really need that other person you've identified to help get through this, because it is forcing healthcare providers to do something against your wishes in the moment. So there has to be somebody there to be that second voice for you. And then there also is that additional checks and balances where you have to have 2 clinicians say, yes, this person really does not have capacity. Like, we want to make sure that, we're doing this because this clause is really coming into effect. So there has to be 2 clinicians to say that you do not have capacity. And then they're able to give or not give the treatment that's listed in the Ulysses Clause. It can't be vague, like it has to be very, very specific. So as I mentioned, like maybe there's a specific medication that you're going to want to take or be given, even though you also know you're going to say no to it in the moment. So it has to be something very tangible that can be enforced. So how do you include it? As I said, you have to have an agent. You have to specify exactly what treatments you're allowing your agent to consent or refuse to over your objection. And then you have to have your agent agree in writing to accept the responsibility to act over your objection in the moment. And then you also have to have a physician or other physician's assistant, advanced practice registered nurse, affirm in writing that you appear to understand this particular clause, that you're authorizing or rejecting treatment under this provision. And then you have to have the patient representative, an ombudsman, or an attorney licensed to practice, probate court designee, kind of those same people who help you execute an advance directive in a facility. They also have to sign off that says like you appeared to understand this explanation and that you're doing it of your own free will. So there's a lot of additional safety checks in this because it's, again, asking your healthcare provider to do something over your objection. Okay, so that's kind of like a broad overview of just an advance directive and all of its many parts, including the Ulysses Clause. We have had some litigation on this topic, and this comes into what I had mentioned before around listing in your advance directive. I do not want antipsychotic medications, for example, to be administered to me ever. We had a case, Hargrave versus Vermont, where they had identified they wanted to refuse administration of any and all antipsychotic medications. And then there was an application to involuntarily commit her and then involuntarily medicate her. And if you have a validly executed advance directive in Vermont, they cannot do an involuntary medication order. So if you've said you don't want psychiatric medications and it was validly executed, you cannot be involuntarily ordered to receive medication. So that's kind of what that was. You can still be hospitalized. So this is where, when your healthcare preferences impact or have the potential to impact others, or the well-being of others in that same setting, then, you know, it's a matter of like the competing interests. So you can identify your preferences. They're not necessarily going to be legally enforceable, like saying, I don't want that particular type of medication. That's something that's legally enforceable because it only impacts you. But for example, emergency involuntary procedures, where you're posing an imminent serious risk of harm to yourself or others, that's something you can say you do not want, but because it's impacting the safety potentially of other people or yourself, in an emergency situation, they may still be able to implement emergency involuntary procedures because of that competing interest. And again, same thing with the hospitalization piece itself. You can say, you know, you don't want to be hospitalized, or maybe you don't want to be hospitalized at a particular hospital. Those preferences should still be taken into account, but they're not as legally enforceable as something that only impacts your own health or treatment preferences. But it's still important to include. So I absolutely encourage people who want to avoid particular hospitals to identify that, because it should still be taken into effect.
We have a question, Lindsay, from
Sure.
Tricia.
Okay.
If someone does not have a guardian, creates an advance directive, and then goes into an order of guardianship situation, is the advance directive still applicable?
Yes. If you have validly executed an advance directive before being under guardianship, your advance directive is still validly executed.
Okay.
And your guardian would have to follow what's in there, and your healthcare providers.
Okay, we're getting another question from Chip. Is there any cost associated with registering an advance directive?
No. No, and I even think so DRBT services are free and confidential. The many places that I know that help people witness advance directives offer that kind of as a free service. So there shouldn't be any costs associated with completing the advance directives.
Okay, good to know.
Okay. So I mentioned this already. How does your advance directive relate to psychiatric emergency involuntary procedures? So involuntary medication orders cannot be granted or cannot override the identified directions if you've got a valid advance directive. But when it comes to the use of seclusion, restraint, and involuntary emergency medication, you can, if there is not a way to de-escalate that situation with less restrictive alternatives, then they're still able to do those emergency involuntary procedures. We do, at least in Disability Rights Vermont's form, we have a space to identify, like, if there is an emergency situation, I would like seclusion to be tried first, or I would like, a physical hold to be tried first. Those are still really important to include because what that tells DRVT, if, for example, the hospital instead just decides to involuntarily medicate a person, that they violated that person's rights because they didn't try what was identified to be less restrictive or more in line with your preferences. So it's still important to kind of provide that information in your advance directive so that all facilities are kind of put on notice on the ways in which you will likely best respond when in a crisis and how best to de-escalate you, or what you're going to interpret to be more harmful or more invasive than other procedures. And so those are still really good things to include. They may have to implement some type of procedure, but if you've identified what your preferences are, they should really try to do that versus what you've identified as not being your preference. I think this was just kind of the question that came up. So how does it relate to the powers of a guardian if one's been appointed? So as we said, if you've already got a valid advance directive, it must be honored. It still has to be followed by healthcare providers. And we talked about earlier, if you already have a guardian in place, but you still want everybody to be on board with what your healthcare preferences are, it's a useful document to still complete because then your guardian and your healthcare providers are on notice about what you still want your decisions to be, and your guardian has their own rules of professional ethics that require them to do what's in your best interest and to do what you would like them to do. So, for example, here are some duties of the guardians. They're supposed to maintain close contact and serve the interests of the person. And then if there's any potential conflicts, they've got to bring that to the attention of the court. And guardianships can be limited too, so that's important to think about. Guardians may not necessarily have decision-making authority over healthcare decisions, so it's important to know the scope of the guardianship as well. Does your agent need a special release to obtain information? No. As soon as you say, this is the person I want to be my agent, they're going to have the ability to follow up with hospitals on your behalf and make sure that they have access to information that's relevant to them carrying out their duties as your agent. So the next couple of slides, just like all of the different things that we just talked about, you have the right to do all of these things. You have the right to stay in charge of your healthcare preferences and direct your treatment choices, even when you don't have the ability to do so. And the advance directive is kind of the best way to ensure that that happens. So you have the right to control all of these things. This just breaks it down based on all the different parts that are contained within the advance directive. So yeah, this just goes over all the rights that are associated with all the different parts of the advance directive. So I wanted to give some time, because we still have about 10 minutes or so. If there are specific questions, I could also share what the form looks like. I think that we might have been putting in the chat links to the different forms, but if people want to walk through like our advanced directive just to see what it looks like, I'm happy to do that, or just take general questions as well.
If anybody wants to come off mute, you can ask your question. I had one question, Lindsay, and NAMI Vermont receives phone calls from families, and usually their family is very supportive of their loved one, and then when they have a crisis and they may be hospitalized, then they don't want their family member involved, and that person needs to give permission to the hospital, but yet they won't because maybe, they have psychosis, or they're not, and they won't get the help of that supportive family member where they usually would. So, what would be the best option for somebody? Should they have, when they're well, appoint that family member as an agent so that then the hospital can talk with them?
Yes, I mean that's I personally am going through that in my own family, and that's exactly the scenario that we have is when my family member is well, very wanting my other family to be involved, and when they're not well, it's the opposite. And so we're currently I just printed her advance directive today to go help get it witnessed so that we can avoid kind of those setbacks in when it's really necessary to kind of have that additional support when people are in crisis. So yes, I would definitely recommend that's a really good scenario to just have the agent assigned when somebody's feeling well and has that capacity.
Yeah, yeah. Jamie has a question. I don't know if you want to read it or if you'd like me to. It says, in theory, how often can one update an advance directive? And then also, is it possible to consent for someone to receive private healthcare information but to not make the actual medical decisions?
Yes. So you can update your advanced directive as often as you see fit. There isn't a fee to do that. So I think, and I would have to check in, and I could check in with the Vermont Ethics Network for you. I think now it's probably more readily updated in their system because, interestingly enough, I think up until I think at least like 5 years ago, the Vermont Advanced Directive Registry was actually based out of New Jersey. But in the last several years, it's now housed within the Vermont Ethics Network, which makes it, I think, a lot more easy to update. So in theory, you can update it as regularly as you would like. And then yes, there's definitely a way to allow somebody to just have access to information. Usually, oh, that's my timer to stop for questions. Um, so usually that would be through just a release form. So what I would recommend in that scenario, because identifying an agent does give them, we could take a look at the advanced directive for healthcare agent form, but typically that does presume that you're giving them some authority to make decisions. So if all you want to do is enable somebody to have access to your medical information, then I would recommend instead completing just a records release form. And that would be hospital specific usually. So if you or your primary care provider or your local hospital, I would recommend getting their release of information form and signing that instead of doing the advanced directive.
Mhm. Anybody else have any questions? You can just come off mute. I actually had a question. When somebody's incarcerated under the Department of Corrections, and there's usually a healthcare facility that works with people incarcerated, and they have their own medication, right? So even though you might have a treatment plan that works for you, they may not be giving that to you because you are now under the Department of Corrections. Now, if you have an advance directive, will that uphold in that case? To be able to use maybe a medication that's not on their formulary for corrections.
That's a great question, Lori. I think that they would have to. I think the burden would be on the Department of Corrections to explain why they can't follow the advanced directive in that scenario. I would interpret that to be more of like a reasonable accommodation request. Like if somebody's taking a specific medication in the community and needs it in corrections, but it's not on corrections list of medications,
Right.
I think DRBT would handle that as a request for an accommodation. On the advance directive, in terms of, yeah, and I mean, I think it could be on there, and I think it would be enforceable unless for some reason corrections got a really, I don't know how they would justify not providing that, especially if, there's a support person or a provider in the community that's able to like prescribe that and provide that medication. The only scenario that I'm thinking of is if it's some sort of, I'm trying to think of like a medication that would be, present some sort of a risk or undue cost or something like that on the correctional facility. But I think it would be an individualized decision for sure.
Okay. Thank you.
But that could be a question that comes. So, with medication specific requests for people who are incarcerated, the Prisoners' Rights Office handles medication related issues. But anything other than medication or physical disability needs could come to Disability Rights Vermont.
Okay.
And if there's an advance directive, you can come to DRBT as well.
And I think we had someone who raised their hand. You can go ahead. I'm going to remove the spotlight, Lindsay, so we can see everybody better.
Um, Hi, this is River. If you don't have an advance directive and you're incapacitated, do medical providers do whatever next of kin says to do?
Um, no, well, that's a good question. So you still have, even if you've determined, unless there's an emergency situation, you should still be able to make your own decisions, regardless of your capacity to kind of weigh that decision in the moment, unless it's like a life-sustaining decision and there's no
I
indication
guess
or.
what I mean, like I've had a major concussion where I couldn't think, and now have struggled with long COVID and have had brain fog. I've also had hypomania. So like there's just moments where I really could not make decisions on my own. So thinking about that for the future.
Yeah. So I think that, now would be a great time to start thinking about those decisions. Again, capacity is kind of presumed. So if you have the ability to kind of weigh the pros and cons, or there are specific types of treatment that you feel very strongly about or feel strongly against, like I think that now would be a great time to start talking those through with your support network or providers, and just documenting those. I think capacity is really about individualized decision making on a particular thing. And so if you can weigh the pros and cons and understand the risks and benefits of a particular treatment, then you still have capacity, even though you may be struggling with brain fog and struggling with making decisions. It may take you a little bit longer, but I would say, go ahead and start thinking about those things and try to execute your advance directive, and identify somebody, if you can, who might be able to help make those decisions for you. And again, you can identify when you want your advance directive to go into effect. If you want that to be now, while you're like, okay, I know right now I actually need support now, not when a provider has told me that I don't have capacity, but I want that support now to help make these decisions. So I would encourage you to take a look at the form and start thinking about what your preferences are and having those conversations.
Yeah, absolutely. This makes sense. So you're saying though that without an advance directive, like next of kin doesn't make decisions for you?
Not unless they have some legal authority to do that. There's actually, so I can I have it and I'll send it along. So the Vermont Ethics Network prepared some slides as well that kind of talks about this. There's different levels of authority and shared decision making. So there's an advance directive where you can identify somebody to just kind of take over when you don't have capacity to make your decisions and to follow your wishes. Then there's guardians who still have to follow your wishes. Then there's people you can kind of just identify in your support network, and those people who have like surrogate decision making, but not any legal authority. When it comes to healthcare, there really has to be somebody who has the legal authority to make that decision for you. Otherwise, your healthcare providers shouldn't be providing you with treatment without your informed consent. So you'll want to kind of, if you want your next of kin to be able to weigh in on decisions to support you, you'll want to document that somehow. And an advance directive would be the best way to do that. And if you don't want them to be able to do that, then you don't need to do anything because they don't have the legal authority to do that for you without you giving them that authority.
Oh, thank you, Lindsay. We're almost at time. I'm not sure if anybody else has any other questions, but you can also email Lindsay, and we'll provide her emails right there in the chat. Thank you, Christina. And also, we're going to be sharing all the links from today, and we really hope that you'll complete our feedback form to be able to give feedback about this learning session. Thank you so much, Lindsay. This has been very informative, very comprehensive, and we all got a lot out of it.
Well, thank you so much for having me, and I'm available if you have any questions or want to talk about advanced directives more.
Excellent. Thank you. Please sign up for other sessions, everybody.